The principles asserted in these pages must be more generally admitted as the basis for discussion of details before a consistent application of them to all the various departments of government and morals can be attempted with any prospect of advantage. The few observations I propose to make on questions of detail are designed to illustrate the principles rather than to follow them out to their consequences. I offer not so much applications as specimens of application, which may serve to bring into greater clearness the meaning and limits of the two maxims which together form the entire doctrine of this essay, and to assist the judgment in holding the balance between them in the cases where it appears doubtful which of them is applicable to the case. The maxims are, first, that the individual is not accountable to society for his actions, insofar as these concern the interests of no person but himself. Advice, instruction, persuasion, and avoidance by other people, if thought necessary by them for their own good, are the only measures by which society can justifiably express its dislike or disapprobation of his conduct. Secondly, that for such actions as are prejudicial to the interests of others, the individual is accountable and may be subjected either to social or to legal punishments if society is of opinion that the one or the other is requisite for its protection. In the first place, it must by no means be supposed, because damage or probability of damage to the interest of others can alone justify the interference of society, that therefore it always does justify such interference. In many cases, an individual, in pursuing a legitimate object, necessarily and therefore legitimately causes pain or loss to others, or intercepts a good which they had a reasonable hope of obtaining. Such oppositions of interest between individuals often arise from bad social institutions, but are unavoidable while those institutions last, and some would be unavoidable under any institutions. Whoever succeeds in an overcrowded profession, or in a competitive examination, whoever is preferred to another in any contest for an object which both desire, reaps benefit from the loss of others, from their wasted exertion and their disappointment. But it is by common admission better for the general interest of mankind that persons should pursue their objects undeterred by this sort of consequences. In other words, society admits no rights, either legal or moral, in the disappointed competitors to immunity from this kind of suffering, and feels called on to interfere only when means of success have been employed which it is contrary to the general interest to permit, namely fraud or treachery and force. Again, trade is a social act. Whoever undertakes to sell any description of goods to the public does what affects the interest of other persons, and of society in general, and thus his conduct, in principle, comes within the jurisdiction of society. Accordingly, it was once held to be the duty of governments, in all cases which were considered of importance, to fix prices and regulate the processes of manufacture. But it is now recognized, though not till after a long struggle, that both the cheapness and the good quality of commodities are most effectually provided for by leaving the producers and sellers perfectly free, under the sole check of equal freedom to the buyers for supplying themselves elsewhere. This is the so-called doctrine of free trade, which rests on grounds different from, though equally solid with, the principle of individual liberty asserted in this essay. Restrictions on trade, or on production for purposes of trade, are indeed restraints, and all restraint, qua restraint, is an evil. But the restraints in question affect only that part of conduct which society is competent to restrain, and are wrong solely because they do not really produce the results which it is desired to produce by them. As the principle of individual liberty is not involved in the doctrine of free trade, so neither is it in most of the questions which arise respecting the limits of that doctrine, as, for example, what amount of public control is admissible for the prevention of fraud by adulteration, how far sanitary precautions, or arrangements that protect workpeople employed in dangerous occupations, should be enforced on employers. Such questions involve considerations of liberty only insofar as leaving people to themselves is always better, caeteris paribus, than controlling them. But that they may be legitimately controlled for these ends is in principle undeniable. On the other hand, there are questions relating to interference with trade, which are essentially questions of liberty, such as the Maine Law already touched upon, the prohibition of the importation of opium into China, the restriction of the sale of poisons, all cases, in short, where the object of the interference is to make it possible or difficult to obtain a particular commodity. These interferences are objectionable, not as infringements on the liberty of the producer or seller, but on that of the buyer.